Are we ready? Oh,
Yeah,
yes.
go ahead.
Okay, good morning. Welcome to JCIT as we open our meeting. Casey, could you read out who's on the phone?
Sure, we've got Ed Wells, Beverly Walker, Mr. Soltero, Chris Ricci from Tyler, Judge Stiff, Dean Stanzioni, Doug Gowan, Evan Acosta from Tyler, Jamie Gillespie from Tyler, Jesus Acevedo, Justice Doss, Mr. Caraco, Nancy Reister, Roland Johnson. Let's scroll down. And then Steve Shank, Todd Cope from Tyler, Travis Hodges, Laura Hinojosa, and all of us in the room. And we do have a quorum today, Judge.
All right, that's great. Okay, let's start by looking over our minutes.
So I had that on the agenda, but I apologize when I pulled them up today, they were not done. So if you're okay, we can suspend that to the next meeting.
Okay, we will hold then those minutes. I wondered because I so let's hold that and go ahead and move to our next item.
So for our next item, we've got our update on Tyler.
Yeah, exactly.
And we have Terry Derrick here live and in the flesh. And Terry, what I'm going to do is I'll go ahead and share the presentation. Everybody can see it.
Great. Thank you, Casey.
All right, there you go.
Great. Well, it's good to be back. It's been a while since I've been here in person, so it's good to see everybody here today. And I'm good to be here. Casey, if you go ahead and go to the next slide. Just a quick update on where we are with the eFile Texas program. We've got about 640,000 users that have been created today. We're processing about 42,000 filings per day, about $1.3 million being collected and dispersed amongst the courts. In terms of our JP progress, we're almost in 50 counties across the state. We're making progress slowly but surely. And I think one important metric is the number of integrated courts that we've got. So right now, 83% of the courts that use eFile Texas are integrated, and there's only 64 remaining district clerk or county clerk offices that don't have an integration in some capacity with eFile Texas today. So the vast majority of the state is now integrated, which is a good step in the right direction.
And Terry, when you say that, are we talking electronic filing or e-filing and research?
Talking electronic filing. Okay. Yep, electronic filing.
Terry, but what's the population of those?
I think they're mainly small. I think they're the smaller size counties, but would have to pull that in. Most of the mid-sized and large-size jurisdictions are integrated already.
25,000 or less, probably.
Probably, yeah. So
I can give them an answer based on the reporting back in 2019. We determined that the counties that had a population of less than 80,000 were unlikely to participate, and all but one county that is participating, 49 counties have a population of 80,000 or more. One county with less than population of 80. And that's Duval County.
Is it, so county with the population of 80,000, how many, that should be at least 2 or 3 courts?
Should be, yeah. Yeah, we've got a list of all of the integrated courts and the non-integrated courts. It's actually out on the efiletexas.gov. If you go down to the footer, there's an integration report where you click on it and see an updated status. You know exactly who is integrated and who's not.
Okay, and then when we look at this and we're looking at our map, are those, what are the green things?
Those are the JP offices.
Are those the JP offices
Yeah,
that are,
There may be a build out. I think if you go one click, Casey. There we go. That's the JP precincts that are live today. And not all of the precincts in every one of those counties is live, but it's
Right.
a subset.
Judge by judge.
and do they just contact you? Is that
Yep.
what happens?
They do. If they're interested in doing e-filing, they just contact us and we stand up a project team and implement it like we would be implementing any.
Okay.
All right, Casey. All right, great. So self-help.efile Texas is doing well. We got about 45 interviews that are out and in the wild. 7 of those are integrated. We're slowly seeing the utilization as well as the completion rate uptick, which is good. It is a little low, but when you compare it to what you see across the country, it is pretty normal. A lot of times we'll see self-represented litigants start the process and then disengage for a number of reasons. Could be a change of heart, could be that they felt like the process may have been just too complex and now they want an attorney to help them, or a series of other reasons. It is interesting to note though, that about 3/4 of all of these filings are filed electronically.
Yeah.
And I think that that's important because what we're seeing is though, even though that a small portion of these are integrated with eFile Texas, it shows that they're capable of being able to save off the record, go to eFile Texas and then file those. And I think that that's an interesting thing to watch as we start to see this move forward, because I think it's saying that the current users of the system are being a little bit more technologically savvy in terms of being able to use computer systems and electronically file records with the court. All right, Casey. Research Texas update. We've got over 50,000 registered users using the system, which is good. We've seen almost about $140,000 in document purchases over the last few months, which is good. This is money that we've collected and then dispersed to the courts for serving up those documents. I think that's an interesting data point simply because we don't have comprehensive records in the system just yet because of the lack of orders and judgments. Still being able to process $140,000 in document purchases over a few month period is still pretty noteworthy. And so that obviously the number one request that we're hearing from legal professionals is those comprehensive records. And then from the court side, we received several requests to add criminal records inside of research. Mainly the driver behind that is a lot of these courts and clerks want to decommission their current local repository, their online record repository, but are unable to do that until they have all of their records, including criminal. So a lot of them are continuing to maintain that platform and bearing that expense until criminal records can be added.
And the criminal records are not added right now because of inaction on the part of the Court of Criminal Appeals to approve it. So we really need to set up another meeting and get to work on that. And once we get done with some of our major things we're going to do today and some other things, but that needs to be a top priority, that and getting the orders in there to make it a more robust system.
Sure. All right, Casey.
I'm sorry, just on Research Texas real quick. Something came up
recently where I was looking for a trial court record,
You're looking for a, which?
looking for a
kind of-
trial court record
Yeah.
in Research, Texas, and couldn't find it. And Terry was very helpful in getting this resolved. It's a bit of a long story, but the point that I wanted to make about it was that it had been marked confidential,
Yes,
and we couldn't figure out why. And then there was the question of who has control over that, and if you think has been incorrectly marked confidential, who do you contact and how do you get that resolved? And I don't know that there's a clear answer to what that process would be, but I think it's something that we should probably think about.
right. I mean, so that issue came up because actually the form book for family law has every single document filed in a family law case marked confidential.
Mhm.
And so you're right, there is no right now clear strategy for, that's clearly not supposed to be that way. You are blocking someone from access to the courts and doing a runaround. And so we do need to talk about that, because I don't know how you get that unblocked. We leave it to the lawyers to mark it. And so there's no clear path.
Yeah, and not, we're gonna talk more about
Yeah,
sort of the case that's been filed.
right.
And then what the outcome of all that might be, and if that might also
That's going to
lead to
facilitate it.
more
Correct.
marking of things
Yes.
confidential, because of people's concern that it's immediately available.
Correct.
And so that's another reason I think we probably need to look at how all that works and
Yeah,
how one might be able
right.
to address that.
Just an update on our new development for the 2.0 iteration of the eval Texas program. That second cycle of development work has now been implemented in production, but we haven't enabled some of the features. That'll be a methodical rollout, which I'll talk about on the next slide. But I do want to call out a few key features in this second version. The first one is the composable security model. What that allows for us to do is essentially adjust the security on a granular local level. What it really does is it allows for us to roll out what we call our admin console. And we've rolled out our admin console throughout the country in unified states where the composable security model and localized configuration isn't required. The admin console does is it gives clerks and IT shops on the local level the ability to be able to configure and manage their configuration on their own. So if there's legislative fee updates, if there's judicial changes, if there's clerk changes, if there's anything that they need to do on their side, they'll now have that opportunity to manage that on their own. So I know in places like Harris, where they've asked, can we manage that ourselves? We'll now have the ability to do that. And Harris District Clerk will have the ability to manage only Harris District Clerk's content and be able to then add those filing codes, move them out, configure them, do what they need to without the need of Tyler's support in the way. So that's a good value add, I think, for the program. The second one is yeah, so it's great. So we were targeting at the end of the year, but I think we're actually ahead of schedule. So I think it's probably going to be right at the beginning of Q4. So probably in the October time period is when we're going to be able to roll that out and make that available. So actually ahead of schedule on that one. So that's a good one. Second one, I think, is really the multi-factor authentication. This is really just in the very security conscious world that we live in today. This is an important one for the program. And then the final one, I think, is the enhanced return for correction process, which really lays the foundation for our cycle 3, and then being able to use that and things for like the grace period. So today, the clerk has to evaluate the original docket date and then make a determination if it's filed, returned back within that standard duration window that we allow. We can actually automate that here in cycle 3. So cycle 2 sets that up for us to do that.
And what would cycle, so when you say automate, what function is actually automated?
Yeah, so today, when someone files a filing and the clerk has to return it for correction, they have a period of time by which the filer returns it back. And when they do, and the clerk reviews it again, there is a view panel where they can actually see the original docket date, and then they can make a judgment on whether or not they want to grant that original docket date or not during that review process. And what we're enhanced return for correction is setting up the foundation for which we can then automate that docket date when they file it back within that same window can automatically be defaulted to that original. So the clerk won't have to make that decision, say, hey, how many days was this, and factor in those dates. We can actually then accelerate that.
So that would be defaulted in, but on the other hand, would ones that were filed outside that 10 period be defaulted out?
We can, yeah,
But
absolutely.
is that feature in there or?
It will be in cycle 3. Cycle 2 sets it up because before, if you remember, we had accept and reject.
Right.
Now we have return, which is
Right.
different than reject,
Correct.
which gives them the latitude to be able to configure it that way. So cycle 3, you'll have some configuration around that, and if we need to create a policy around what the default configuration is, and
Okay,
we
we
can-
probably need to work on that.
Sure. Yep. And cycle 3, I'll also call out just a few additional items, the bulk e-filing, that'll be nice. I think that gives, those bulk filers specifically for things like landlord tenant cases, evictions, be able to file in bulk and be able to manage that also on the clerk side. And then fee schedule changes and effective dates. Today, if there's legislative changes, it's usually Tyler staff waiting to make those updates on the day in which they become effective, generally at midnight. So if they become effective on January 1, that means our staff gets to work on New Year's Eve. And so changing that to have an effective date means that we can set it up, let it run its course, and then at the stroke of midnight, that fee will kick in. Same thing happens on our October 1st effective dates. And then the last one is the ability to suspend and deactivate accounts. I think that's important. We've had some incidents where I think that would be valuable feature that we had. So, all right.
And then let me ask one question on the admin
Sure.
feature that allows clerks and whatever to configure and deal with that. Because we really are stress uniformity, e-filing uniform across the state, we have uniform standards and that sort of thing. Does that allow the clerk to from those standards, or is it more about configuring like their case management flow, their business and that sort of thing?
It gives them the ability to do that, but we can manage what we give them access
Okay.
to do, right? And so how far we move that forward in terms of the availability of code configuration in that admin console is completely up to us. We can disable certain functions and enable others, but
All right,
it's really primarily going to be used for making changes at their local level that are necessary to continue their operations without the need of Tyler's support.
And just to add on to that, I think one of the intent of that is that we get people like who probably makes several changes to your queues a week and has to call into Tyler, put in a ticket, wait a day. If it doesn't get done, call me, then I call Terry, then it gets done. And this way we can avoid all
Oh, I
that.
think that's great.
And
Yeah,
just
no,
let
no,
them-
but I just don't want to, where all of a sudden everybody's reconfiguring.
Oh, yeah.
We have all these,
No,
different-
no, no.
just like we have standards, everybody's just got to reconfigure to something uniformity, because that is a constant complaint I get. It's a lack of by the lawyers in this state of filing.
Right. Well, we could bring up a list of the available options in the next JCIT
Okay.
meeting and even share it beforehand if appropriate. And then-
That
I
would
think
be-
that would be great
that
to
would be
put
great.
into our standards,
Yeah,
Bob, if we
do that.
and run it that way.
yeah.
Understand. So for the effective dating, who changes who puts in the effective date?
For the fee codes,
Yes.
yeah, it depends on whoever has access to that admin code. So the admin console. So if you had access to the admin console, you could do it if that is one of the code tables that we make available for the policy. Otherwise, it could be Tyler representatives, but it is an option. It is one of the things that is in the admin console.
Well, the one thing that you keep in mind is like when you have the weekends and holidays, January 1st is a holiday.
Yeah.
So the fee code may not go into effect January 1, it may go into effect
January 2.
December the 31st or a different date depending on where the date falls.
Mhm.
If it falls on the weekend or so forth and so on, so.
We have a number of cases where there's a change of venue. And it's going from Harris County to another county, or from another county to Harris County. Will you be able to handle local control being different from one counties and others.
Yeah, the use case that you mentioned, I don't know how that correlates, but yeah, you can control at the local level, so it'll be down at the granular level, so. At the court level, right, district clerks can manage district courts at their respective jurisdiction, county courts for the county clerk and so forth.
So, hey, Tracy, going back, so if, January 1st is when and it's a holiday, but it's a new fee deal. People are still filing on that holiday, lawyers are
Right,
filing
it's a
cases, so is
weekend,
that
it's-
gonna be applied then, if it's automated?
If it's a weekend, it's being filed the third, right?
Right,
So you don't want the fees to go up on January first. I mean, I'm not saying it right. Even if the fees go up on January first, it should not be accepted into your system.
So-
until the third.
so what are but when I go to upload, which is when it's deemed filed, and it's January 1st, what fee am I paying when the legislature has said, and I'm putting my fee in as the lawyer?
Right.
Right, say I'm just using the Tyler, Tyler EFSP, whatever, I'm gonna go up. And I'm gonna assume I'm gonna put in the $20 that it went in, correct?
Sure.
Okay, and so that would go in, and then you don't deem it filed until the 3rd or whatever, but it does become effective in the system itself, correct?
Once we set that date, then
Yeah.
as soon as that date happens, then now that fee is.
Yeah.
applied.
So you're not gonna, unfortunately, I don't think you're off the hook. I mean, in other words, that,
The problem is that what happened last year. So, Saturday, the 31st. Saturday
Yeah.
was the 31st,
Yeah.
I think Sunday was the first.
right,
If you file that on the 31st, you're deeming it filed on the 3rd or the 2nd, whatever the case may be. So the 31st, the fees have to go up if you're filing on the 31st, because it's not gonna be deemed filed until January.
Cause it fell on a weekend. or
Because
Because
something.
it fell on a weekend or a holiday.
it gets advanced, right?
Right.
So there's a
you
little
have
bit
to
of law that
actually-
needs to go.
yeah, we
into
need
what
to
those
think
things
this through
Correct.
in terms of how that works, because the legislature, they're like, that's the fee. I mean, I don't know.
Well, that's
I
the-
need
that's
to
the
see what their
problem.
legislation.
Filed on a weekend or holiday, it's being filed the next business.
No, I understand all
Right.
that, but when you're inputting to go ahead and send your money in, right? And
Well,
I'm
I-
doing it the 31st and the legislature hadn't passed it on the 31st, what
Right.
money do I send
That's-
in? I'm
that's
just thinking
what-
of,
That's what we struggle with.
Yeah,
every time
yeah.
The fees go up, because my guys end up having to work on the,
Yeah.
on the New Year's Eve, because Tyler doesn't, we have effective dating, but they don't.
Right.
So we have to watch it and make sure our fees go up at the same time they do, because when we accept the filing and the fees come down,
They better match.
my date is already on the new fees, and if they're coming down with the old fees, we're.
Yeah,
not
we just-
balanced.
no, thanks for bringing that up, because
Yeah.
it's more questionable than I thought it was just like automatic, and it sounds like there's more issues
There's more
involved with it that we
Yeah.
need to talk about.
If I
Okay,
can, during the course of that window,
Yeah.
Justice Simmons that you're referring to, that is kind of a very small
yeah,
number of cases.
Yeah.
And what we did in Dallas County, we had to, after the beginning of the new year, we did this with, as it relates to SB 41.
Hmm.
We had to go back and make adjustments to those particular cases that were impacted for that date.
okay,
Right, but that's a little bit of cases for you, it's a bunch of transactions for
yeah.
you. And you're talking in
Transactions,
the
I-
thousands
but-
having to adjust, it gets
But-
crazy.
I guess it just depends on the number of lawyers who really don't care about holidays, would rather work, but.
Well, they may be running into a limitations thing or
Yes.
something. I mean, you're gonna do limitations and they're looking at it going, okay, good. I
Yeah.
get this cheaper rate because the legislature says I don't have to pay $50 until the 1st, and I'm filing this on the 31st, and it's being
Yeah.
uploaded
Right.
at that time and deemed filed that day, not the 3rd. It is,
Holiday ends up
you know what I
being the
mean?
third,
well, that's right, but I mean, in terms of if they end up filing on a Friday,
though. That's just.
before 5, you would just go ahead and they would know it's okay, but after that, then they ought to know enough they aren't gonna know.
Up to
You're-
midnight, they can file, up to
Yeah,
midnight, they can
yeah,
file as much as they
yeah.
want, but then after that,
Yeah, no, that's right, yeah,
right?
Yeah.
But after that, if it's on a holiday.
Yeah.
Or
yeah,
a weekend, that's where it gets.
yeah, okay, yeah, it's interesting, all right, sorry.
Good. Casey, last slide.
Okay,
So we talked about how we implement it, but we're going to enable those features in cycle 2. So this is the schedule by which we're currently operating under in terms of enablement. I called out a couple of these because I think they're pretty noteworthy in terms of production implementation
Okay.
or enablement. The composable security model on June 26th, our multi-factor authentication with Okta on July 10th, and then the requirement of that on September 1st.
Tell me what the practical effect of the multi-factor, how that's gonna work in this system.
Yeah, so it would be just like any other multi-factor authentication. We're using Okta as that tool, but it would be like a push notification or a dual factor. So whether you choose to do it as an email or your cell phone and text message to be able to accept it, and there's other applications you can use like Okta that would actually then give you that ability as well. So you can pull up the app and say, okay, yes, this is me, send it to your phone, and then you can validate that. The reason I called these out is because they do have implications around the EFM and our integration partners. And so it's important for everybody to kind of understand this is the schedule moving forward. We're going to continue to communicate these on all of our compass checks as well as all of our written correspondence with those partners, but we'll continue to stay in the setting as well. The more we vocalize it, the more everybody will be prepared.
So the existing users grace will end.
September 1st.
September 1st is when it'll be required for everybody.
And
How much
we,
time are we gonna nag them and say, you ought to set one of these up
Yeah,
until the deadline hits, right? We're gonna-
yeah, so from July 10th to September 1, and then
I'm not suggesting by any stretch of the imagination, don't do it early, because we know that's not true.
Right, no, we know that that's not true.
Enough months in
Yeah.
advance.
we'll be warning them, and then we have the ability to where when this goes into production on July 10th and we start pushing, we'll be monitoring how far along the path are we. And we have the ability to push that grace period if we need to, but it's one of those from a security standpoint.
It's necessary.
You have to do it at some
I
point.
know from experience.
how are we publicizing this?
Yeah, we're doing it right now through the EFM compass check with the partners. We haven't communicated this externally to the filing community and the clerk community as of yet, I don't think.
I don't think I've seen that yet.
But we'll put together a communication strategy. It's kind of like one of those situations where you don't want to communicate it too early and then they get excited and then it falls off again.
Yeah.
And they lose interest by the time you actually do need them to be paying attention.
Okay,
But it's something that's gonna affect the clerks, right? It's just a UI kind of look and feel.
That's right, but what we're hoping though is everyone is aligned and on the communication, because Tracy, as you know, sometimes the filers, when they have issues, and sometimes when
They
other
just
people have
call
issues,
you.
they call the courts,
Right.
right? So the more.
yeah, that's what I'm,
So the more we communicate, the better.
Okay, yeah, we have little attorney focus groups, reporter with the attorneys, so that would be good to bring up.
Yeah.
Those just to see how it looks, once we do know how it looks.
Yeah.
So they would know.
Yeah, I think we are, yeah. Yeah, great. That was my update. Are there any other questions?
any questions? Okay, thank you very much.
Thank you.
And if you don't mind, are you gonna put that on the website or circulate the
Yeah,
presentation to us,
happy to do
please?
that. Yeah.
Thank you. All right, thank you very much. Okay, so next, let's move on to our subcommittee, our program updates, and we've had that. So let's look at our subcommittee updates, and so we're going to now address the letter from the Supreme Court regarding public access to court records. We've had a subcommittee working on that issue. You all were all sent, should have been sent the information regarding the original letter that came from the Supreme Court approximately 2 years or so ago. And then we had a recent, back in October, we had another letter from the Supreme Court that asked us to review our prior recommendation regarding, and we're talking about access to court records, remote access to court records. It came up back then as a request from a media news company and news purveyor to get immediate access to court records. We recommended that that not be approved prior to court review of material, clerk review of material. When it came back again in October and the Supreme Court asked for our recommendation, we again recommended that that the media not be allowed, or the public, to access filings prior to the clerk's processing of those filings. So in other words, this review or the documents would be made available before the clerk accepts the filing as a court record. So the court came back in, we gave our recommendation in December, and then the court came back and asked us, okay, if we do grant this immediate access, talk to us more about, standards on how quickly court clerks should turn around filings, and what other necessary things would there be needed, such as a watermark to help differentiate between officially accepted court records and just filings that have not been processed by the clerk or accepted into the court record systems. So we have circulated those documents for everyone to look at. I don't know if everyone has had a chance to do that. But I just wanted to give everybody a background. Is there anything any of the subcommittee members would like to add about what our review included? We looked at lots of court cases on the subject matter. We also had clerks on the committee and talked to them about the process of how it worked. And so we came up with a proposed standard of how quickly court should turn around these the processing of court filings. And can you put that, can we share that screen, please? So based on a review of some significant federal court cases that have come out more recently, we looked at a standard to recommend that documents received by the clerk should be processed on the same day that they are received when practicable. So that recognizes, when we have weather and, there's snow or giant freezes and the courthouse is shut down, that you can't process them in one day. But if it's not practicable by the end of the next business day. But we also say that the documents that are received 30 minutes before closing hours. So some courts close at 5, so documents received before 4:30 or between 4:30 and midnight, and then a weekend and holiday, we should take into account that the clerks don't work then, and therefore it needs to be processed by the end of the next business day following receipt when practicable, and again, when not practicable, by the end of the next business day. So you don't have to require, processing after, regular business hours, weekends, holidays, or when the courthouse is closed. So that is kind of the suggested standard. It was based on, like I said, a variety of cases, and then also taking into account what our rules of civil procedure provide regarding filings. So I'm going to open the floor to discussion about this standard. Yes.
This may be a minor detail.
Yeah.
I know at least in Harris County, the courts close at 5, and the clerk's office closes at 4:30. So we might want to be a little bit more precise about what closing hours we're talking about. I don't know if that's unique to Harris County, as a lot of things are, or we have that kind of circumstance in other places.
So is it the clerk's office that closes at
4:30.
4:30, but as I understand it, actually the clerks stay longer to process
Well, they stay, but the.
Yeah.
Case
official-
initiation.
case initiation documents, so those end up being longer. But the problem is that courthouses close at different times across the state, and that's why we
That's
couldn't
where I'm
do.
going. Are we talking about when the courthouse closes? When the court closes?
Yeah.
Or when the clerk's office? Because that's not always the same thing.
Rural counties, it's a huge difference. They'll close sometimes if there's a playoff game.
Yeah.
Everybody leaves at noon to drive.
And that's not just the clerk, so it's your court, right? Is it the courthouse that close it, or is it just the clerks?
We had a clerk who had a child who was on a volleyball team. And that volleyball team played out of town every Friday afternoon or Saturday morning. And they closed the office and everybody went. We have another one that historically closes.
That's a two-man operation though, is that?
2 or 3, yeah. Then we had one that they worked through lunch,
All right.
but they thought more people would file things during the lunch hour. So in order to not incur overtime, they closed at 4 every day. It was clerk's office closed at 4 every single day.
Okay,
So all counties are different.
we had some other discussions around whether we should be using words like judges or courts and
Right,
clerks. And we
exactly.
decided to try to remain as neutral as possible. on that.
right.
And so we, at one point, we had court and then I
We had
think it was
clerk.
suggested it was clerks and then we went back
Back
to
to
something that's
courts.
more neutral. And I think I think that's the better choice because we can't answer all these different scenarios. And so, for example, coming Good Friday, there aren't going to be any judges at the Supreme Court and their chamber is going to be closed, but my office will be open. So, you know, I didn't, which one are you going to pick? So I think just leave it the way it is. I don't think, I mean, how's this gonna come up?
Well, who's
If-
governed by the standards?
if,
The clerks.
But if I can, I think the premises of, and following what Blake said, we chose to use that language because if the courthouse is closed, that means it's closed to the public. If a clerk is there till midnight, that has nothing to do with the business hours. That has everything to do with them doing other business processes as they choose. And so we built those parameters around when the county has said the offices are closed and those offices are closed to the public.
I think it's important to explain what this guidance relates to and what it doesn't. Because the advice that I think the Supreme Court is saying is, once it's been electronically filed, it's viewable.
Yes,
It's out there.
right.
It's got the watermark on it, but it's out there, even though no clerk has had a chance to look at it. This guidance is suggesting to the courts, you need to look at it and accept it, or it's gonna be out there all weekend.
Well,
It's gonna be there for a while.
as I read the Supreme Court's letter, they're looking at 2 different pathways. One was, if we're gonna do immediate access with a watermark, what are the benefits and downsides of it? 2 is if we set a standard for how quickly documents need to be processed, what should the standard be? And so maybe I'm misinterpreting the court's letter, but it seemed like they were still considering what some of our different options have been in our original report. And
You
the
wanna-
standard goes to the latter of, if you're gonna set a standard that, look, clerks need to process these filings, what should the standard be?
Well, you want to pick one. So you want to say clerk's office. Is that what you want?
Yes, because they're the ones that actually process the filings. If we're looking just at the standard of how quickly they need to be processed, so they be available. Because I mean, look, you know, a courthouse is technically open if the jury is still in the box and they're taking testimony at 7 p.m. So, you know, what's that going to do to the clerk? I mean, you know, is each day the close of the courthouse going to change based on which judges worked after 5 p.m.? When the whole
But that's-
point of the
but that's-
point of this whole standard is we got to get these filings processed. Who's doing the filings? It's the clerk's office. That's what I would.
I don't particularly care. I just think that there are a lot of different permutations that we heard about. You know, the building is closed, so it's not really a clerk's office, it's closed and, you know, anyway, so.
I think we worked on that. Let's send that and see what they say. If they need more.
I think, well, one of the things I would say is I'm thinking about the federal court cases, and I don't think did they talk about when the clerks were done? I think they talked about, you know, they need to be processed within a day.
They don't-
And
yeah, they
it's
don't
too
get
bad
into
if your clerk
who's
is gone
responsible
and
for
everybody's
it.
at a volleyball game. Limit, you know, when you should do it. And again, this is accepting that these documents will be available to the public, whether the clerks have processed it or not. It's just a recommendation that you get them done within the first day.
Yep.
So that the official copy can be made available, but this unofficial document will be out there.
And accidentally misfiled or
Yeah,
improperly, you know, standard selection can be corrected. I think it seems clear from all the communication Justice Simmons has had, the Supreme Court is erring on the side of more access. And there is a chance with all the courts and all the different rules we have for a lot of accidental disclosure. If we don't provide that guidance to those courts, that they need to understand what they have to do.
But you know, you're absolutely right, and that's why I say, you know what, there's only so you can beat this horse to death, and then beat it some more. But at the end of the day, if those records are there, if news media want that information and then it's never filed, or even it's returned, oop, I didn't mean to do that. And so the fight is not with the clerk's office, because we're following the law as stated by the Supreme Court. And so that attorney or that particular plaintiff has a fight, now has a beef with the person who published that information.
Yeah, Russ wants to say something.
Yeah, I'm going to go, the Supreme Court issued a whole series of emergency declaratory orders, and in number 58 issued December 30th, they said, immediately make all court records, files, and information, including information stored by electronic means relating to eviction action, confidential to prohibit exposure to the public. And I can explain why I think they did that, is because landlords are going out and seeing that there was a filing made, and they would deny a person an application for rent in another location because they saw in the public record that there was a filing. No, not a judgment, just a filing made. So the Supreme Court in their emergency declaratory order said, let's make this confidential to prohibit disclosure to the public. How do you deal with that and stand?
Yeah, so you should have filing types, right? And the filing type determines the security that applies.
right.
And Courthouse News has said that that's fine, whatever the,
Right, so the
security
matrix
matrix
that we
is-
developed would still apply. So certain juvenile cases, adoption cases, we had a long matrix of documents that just will, for purposes of whenever they're filed, are not available on Research Texas. They're treated as if you, and the other piece is, if you stamp that document confidential, it won't be made available. So that is the thing that we were talking about earlier. Lawyers can just stamp the document that they're filing as confidential, and that will not go up and not be accessible right away. It will, yeah, so,
but to answer your question is, it's the security matrix.
yeah,
So, I mean, if somebody picks the wrong filing type, then it could be
yeah,
available, but if they choose the right filing type, and Tyler's applied the right security matrix to it, then it shouldn't be in this queue.
we need to go back. I'm pretty sure that evictions were on the,
That's wrong.
To Judge Ridgway's point,
Delay.
there's actually a bill addressing that.
okay,
So
okay,
there's actually current legislation says previous evictions are not is restricted information.
okay,
He was referring to the situation though, where there's been no judgment.
yeah,
It's just
the filing,
been filed,
Right.
and now it's
Mm.
published. We're not talking about the reporter now, we're talking about landlords, going through that, looking for information, so they can make a determination. They will bring anything.
So in that
So the-
particular case, in the matrix today, residential evictions are not shown. The cases do not exist.
so we won't, so it wouldn't come up regardless.
They would, even if they got filed, they wouldn't be, news organizations wouldn't be able to
What
see it.
about
What about
commercial or
previous?
industrial?
Commercial is set to where you can see commercial and the documents. And residential evictions that get appealed from JP up to the county courts are on 180-day delay.
But that's something we should probably take up later in talking
Yeah.
about the security matrix.
And go back
but that
through
is
all
the
of that.
fix, though. That is where we would have to fix that.
Because
problem.
we did industrial
Yeah.
and commercial.
Mhm.
It's not just residential.
Yeah, that we have a standard.
Yeah, and
Right.
the standards, then that's one of the things that Bob will go over when we talk about standards, is that committee has been going through the security matrix and making sure that it's.
But back to this point about whether we should say office or clerk's office.
Yes.
I personally don't care. I'm just giving you the background as to why we remain generic. I'm not sure what how it would come up. I mean, how do you picture the argument developing over that? I mean, what's that gonna be? A filer was trying to find it and they look at the standard and they go, oh, but
No, it's
But,
CNS, when, big divorce is filed at 4:45 and it doesn't show up the next day, and they get scooped by someone else, they're gonna.
yeah, but what's the argument gonna be about it? Is it like the judges were
Because the
there?
Courthouse.
The
didn't
judges
show
were
up,
there, so you
but
should have.
The clerk's office closed at 4.
But they're there. The clerks are there. They don't accept filings, I guess, but aren't they there?
I guess we're
Tracy,
going
your
back to
clerks
the
are there
Harris
till
County
6.
Yeah, sometimes we're doing tape, but that's.
Yeah, they're doing the
But
process.
the standard says
Is your office
if it's submitted within 30 minutes of right now, office closing hours.
So you're,
Then it can go, then they can wait until the next business day process.
So,
Okay,
so
so
Tracy,
let's
for
talk-
example,
go ahead.
to address the Harris County situation, do you think it matters? Do you want it to say clerk's office?
I mean, you don't know what office is. I agree with that, but I don't think it matters because of the fact that, 30 minutes before the office closes, everybody's gonna know they have to get their work done by a certain time. Right, the clerks know how much work they've gotta get done. And they know when their office closes and what they have to do to get their filings.
I think that's a good point. I would also say this, from a lawyer's standpoint, they're tired of the lack of uniformity. And when they don't know, okay, when is something going to be, when is the office closed? When does this apply or not apply? When do I have to worry about it being online or not online? And when will the clerk address it? It'd be nice that they have something that looks like it's a semi-normal standard instead of varying every court, every county,
So does
around.
that speak to adding clerks there, saying clerk's
Well,
office?
then, and I agree with you. Why not just say 4:30?
Well, because that goes to West Texas.
That's
where we
right.
have
I get that.
offices. Yeah.
We've got this.
So I would say we had 4:30 in there to begin with. That's how I initially wrote it, was
Yeah.
4:30. And then the committee brought up, there are some counties where actually the clerk's office closes at noon.
Yeah,
So,
no, I.
so that's why we went to that.
The structure of the last sentence seems to indicate that regular business hours is different from the courthouse being open,
Right.
because it's two separate items. there.
Yep.
So whose regular business, or is that the generic 8 to 5, regular business hours? That, I'm.
That's
totally
vague. I
on board
totally agree with you.
Until I saw the split at
yeah.
the end, and I thought, well, now I don't know what. it
Well,
is.
let me explain that. I mean, I think the difference there is that you can have a situation where everyone is potentially able to work remotely, but you can't physically be at the courthouse, or it could be that you don't control the courthouse yourself, right? So I know that we have some appellate courts that are in like a county courthouse and it gets closed. They
Right.
may decide that technically they're not closed. Right. And the idea is to, in that situation, to give them an out if that's what they choose.
I think the difference that I'm seeing, Blake, is I don't think the fact that you're working means that your office is open.
Yeah.
Because this morning I'm answering emails and doing research for work at 6 o'clock in the morning. I'm working. I'm not in the office, but my office wasn't open. at the time, so I
Yeah,
mean, to me,
I
that's.
mean, we could say when there's a natural disaster, I mean, or a state of emergency or something like that. I mean, that's what, when the courthouse is closed, is intended to capture those situations where. And that's usually when that happens, right? When you get a courthouse, that's what it was intended to capture.
I thought at 5 o'clock PM, if the courthouse locks up, that's what that meant.
Well, and then we also talked about the pandemic too. I mean, the courthouse was technically closed for
Right. But it
a couple
was,
of years.
Let's get to that next. Let's talk
How about we amend it so we can say this standard does not require process and filings after regular business hours of the clerk in each county or weekends, holidays, blah, blah, blah.
John, if I may, this is Laura. If I could remind everybody and on the committee and everybody else that we saw in Schaefer that some courts have held that providing them on the same day of filing when practicable and where impracticable, by the end of the next court day satisfies timely access. So we did talk about timely access, I think, at length. We also discussed the fact that sometimes e-file Texas is down, or the CMSs are not working, which kind of satisfied the practicable or not practicable aspect of this statement.
Can we take one thing at a time? Can we go back to whether we should insert clerk's office and let's just.
okay, so let's
vote
look
on
at
that.
this again
Do whatever, so we can.
and see whether the clerk's office documents received, let's see,
I'm fine with adding clerk's office in there. That doesn't
before
bother me.
quote office, what office are we talking about? And that's the second sentence where it says documents received between 30 minutes before office closing hours and midnight on a weekend holiday should be processed by the end of the first business day following receipt when practicable, and when not practicable by the end of the next business day. So, so are we talking about the clerk's office closing hours? Are we talking about the courthouse office closing hours? And let's make sure that we use this consistently throughout, because
Right, we're talking about documents should be processed, the process is documents, the clerks do.
All right, so it sounds like we've reached consensus on putting clerks in there.
I disagreed, but
Oh, you
I want
disagree?
more consistency. I
Okay.
want it to be something more consistent than the clerks head out for a volleyball game. And now I don't know that that's gonna be practicable, you know what I mean? I think, and maybe that's how it's taken care of. If you decide your entire clerks are gonna go off to the volleyball game on a weekday and no one's gonna process that juicy divorce or whatever it is that might be coming through, then maybe that's not considered practicable. But you know what? What's gonna happen to you? They're gonna come sue you? I don't know. I mean, so I mean, to
Yeah.
your point, you know, I just,
Well,
To-
if I could just throw an observation. I mean, maybe we just don't need that second sentence.
No,
No, we
And
need
here's
that.
why. The first sentence says should be processed on the same day they are received when practical. And when not practicable by the end of the next business. So what are we doing in that second sentence? I guess we're trying to give some substance to what practicable and impracticable are.
Well,
I
okay,
think it's
but
more to
here's-
handle
here's the problem,
documents at
though,
8 PM.
Is that if you just had the first sentence, then that would literally mean that if it's filed at 8 PM, then it has to be processed that day.
If it's practicable. If you've got no one in the offices, is it practicable?
Oh, now you're really opening up a can of worms in terms of when is it practical. And that-
Right,
I mean,
and that's why.
This is federal courts don't
It's that the
define
purpose of the
that.
second sentence,
but I-
define what's practicable and what's impractical.
I also want to tell you too, though, that is taken from a case.
Yeah, that's
So the case
that people rely on.
uses language like that and
Okay.
it says. You know, not just the first part, but it also says the second part, that if you. So,
Okay,
Yeah.
fair enough.
That's why the second sentence comes in. Tell me again what you said, that there's something about filing after hours without the second sentence that means they would have to process it that night.
Well, if you just have the first sentence, just take the first sentence and let me give you the example of 8 PM.
Okay, what does the last sentence say about that to you?
Well, what it's saying, so the very first part of the second sentence, are you talking the last sentence or the second
So
sentence?
the last sentence says the standard
Okay,
is not
let's-
required filings processed outside of regular business
Okay,
hours.
well, can we leave that for a second?
Well, that's why I don't understand how you can read that one. The second sentence is saying you would have to process after hours. And then the last sentence says, but you don't have to under the standard ever have to file.
Let's,
Okay, rewrite it for me then. What,
No, I'm asking you.
No, they're saying if you took out the second sentence and left in the third sentence, is that what you're saying?
That's what I
Then does
understand.
that get the thought across of it needs to be processed the same day when practicable, but doesn't
but
require.
no, that doesn't work for what Velva is typing, and what's been brought up before is you get some types of interferences like the internet goes down. That's not included in the standard, does not require. That's more practicable than the office is closed. I think it's fine as it is. I like putting clerks in because we say the word office, and it's really our responsibility to be specific about what office are we talking about. And I'd like to, if we have a motion, I'd like to move the question for the first question about, do we put clerks in there? And then we can move to the last sentence.
All right, so it's been stated that we amend this suggested draft by including clerks before office in the second sentence of the suggested standard. All those in favor say aye.
I,
Aye.
Against?
I'm against.
Okay, nay. Okay, we have two against,
the ayes have it.
and I think the ayes have
Heard
it,
about
so
that.
we will put clerks in front
Aye.
of.
Can I explain why I say nay? Because we're not going through the county clerk's office. But we have to process and put them into the e-file. They're filed as e-file, but we have to process them into our computer systems. Which is same thing the county clerk has to do. Justice courts, we're not going through the county clerk's office.
Wouldn't it be called a JP clerk though?
Pardon?
But
You don't have clerks, do you, or do you?
Oh, heavens, yes.
But do all JPs have clerks? They don't.
Well, small courts don't, but the ones that are doing e-filing all have, but I had.
it's not referring to the county clerk, it's more generic.
If it's, as long as it's generic, I'm okay.
Okay.
The district courts don't use the county.
Well, it says clerk's office, and then
Should we put a "the" before?
this is why we were generic
Well-
before, so.
I think this language is some guidance for the courts, but I think it's helpful for the Supreme Court.
And they're gonna
Well,
redo.
Yeah, they're gonna, whatever we do, we're gonna go, we don't like this.
Yeah, so go maybe to the Supreme Court Advisory Committee or something.
But this is addressing an issue
Yeah,
that
they
the
want,
county
yeah.
and district clerks are experiencing.
Right.
And if it gets to the point, Judge Ridgway, that it comes to the JP level, then they just rip out clerks and just put JP offices.
give me an example. After a 3-day weekend, we come in and we may see 500 to 1,000 new filings that were made over the weekend
Mhm.
electronically. It takes 3 clerks all day on that first day just to get all those processed. I mean,
Yeah.
it's a challenge.
Yeah,
All right, well, we voted,
Now-
so is what's.
well, I think, yeah, we voted, I think we just. need to
Okay,
go
so we
on.
voted and we've now inserted in our recommendation, the words "the clerks." Okay, so now
Okay,
move on.
Now, the last sentence, I will concede, this is maybe overdoing it, like maybe it's not necessary. And it could probably be rephrased another way, like for like courthouses closed, I mean, we could put something in there like, or in emergency circumstances, or, something like that, it's, and we
Yeah.
could drop it entirely too, and I don't think that it would, like you point out, I don't think it would change the meaning.
I don't think it changes it, but for a person that doesn't know a lot, looking at the second sentence, you kind of have to sit there with a piece of paper and go, okay, before what and after what, and what does this really mean? And your last sentence kind of summarizes what you're trying to say, frankly, in the second.
Yeah, and so the first couple of sentences really are tracking federal cases. And the last sentence, maybe it's surpluses.
Which is kind
But
of.
put it in there
summarizes-
because I want to be like, I don't want there to be any confusion about whether people are supposed to be working after hours. Required to come in on a weekend or whatever, on a holiday to process somebody's filing.
I don't think it needs to be there. I think it goes first
Yeah.
protection.
Yeah.
Value of that sentence,
Mhm.
is making sure that they don't get unreasonable, irrational
Right.
demands and people beating on the door because they're lucky. And they're at 1 a.m. counting votes in these small counties, have somebody
Yeah.
in there saying, hey, you're in your office. So I like that that's in there. I just want to make sure the wording is such that we know what it means.
And I think adding the clerk's office in the second sentence actually clearly defines whose business hours you're talking about in that last sentence.
Well, the only question I've got then is we've got courthouse being closed at the last sentence, and I'm just wondering if we need to change that to clerk's office, make them parallel.
I think you
Yes.
should.
Yep, I agree.
Blake, what do you think?
I'm absolutely fine with that. And
Yeah.
like I said, we can sit here for hours and, you know,
Beat the
do
difference.
more of this and they're gonna change it.
We spent several weeks.
So,
That satisfies my.
We had lots.
Satisfies my.
Okay,
Now it's mirrored, so that works.
okay, so let's go back to the committee then. Any other comments regarding this standard?
Do we want to perhaps emphasize to the court which of these two pathways the committee's preferences?
I don't think we need to. And I suspect to, like I said, to the subcommittee, that they may do both. And they may be looking at doing both of these things. So.
All right, so,
Elva has I do like the language you mentioned that. Okay.
so if there's no other, amendments or suggestions, then, what we're gonna move on to then is the, watermark issue that the Supreme Court
Okay,
asked.
Esther is calling me from 6207. Can you answer?
Laura, you might want to mute.
Be mute.
Laura, can I host a mute?
Okay,
There you
Muted
go.
her.
Okay, Casey, can you put up
I can put
the,
up the watermark.
watermark.
This was the one we had the least discussion about. I think everyone just said, we like it, it looks good.
As long as.
As long as I've gotten out of Terry and.
okay, roll it down if you don't mind. so they can
About
see
flattening.
this, or reduce
And
the,
it's not a.
Oh,
yeah, but it can be-
Writer
it can be ended. Yeah.
Hold on.
I want to see that password.
No,
Sorry, security expert over here.
I employ the security experts.
I am the expert that tells the experts what to do.
share my screen. You got it?
No, I got it. It's just ask telling me I need to log in.
Okay.
While Casey's working on that, can I bring up a point?
Yes,
I know it's gonna be new, but I just want to give my 2 cents.
okay,
And I was taking the state's cybersecurity awareness training that is required of all clerks. Just the other day, and it got me to thinking when it starts talking about the 29 elements of PII, personal identifiable information. And out of those 29 elements, I went through and I looked and I said, well, 19 of those could potentially be in one of these court documents.
Correct.
Right? But the 21CA of the rules has about 10 elements that you can mark a data, a document as data sensitive document.
Mhm.
So if the Supreme Court is going that way where everything gets out there unless it's data sensitive, I think we need to change 21CA to include cybersecurity PII information. Because of the fact that any of those points of information can provide security hackers that are looking at these things, which will be looking on Research Texas, can get information and get identity information from people. It
Are
also,
you saying that the 9 elements that are not part of the 10, the attorney can't tag it as sensitive information?
not by the rule. Now, he can put it on there if he wants, because he's the one
That just
driving the
means-
fight.
But you know what, there's others,
The other side can say, you tag this confidential, I don't want a confidential judge, and then the judge gets to make that determination. Right?
Right,
Well,
Correct.
actually, we have no idea. Well, that's what I was talking about earlier. There's no mechanism in place for how you decide whether something.
because it's
should
just
be-
filing when it's over in the courthouse, you know what I mean? And you have it before it, it's not necessarily.
I think if you brought that up with a trial court judge, they go like, I don't know what you're talking about. Like, I don't understand how, except for some of them.
Yeah.
There are exceptions.
there are.
But
exceptions.
I think most of them would be like, that's not something I do. I don't know what you're talking about in terms of how it was marked confidential. That's not.
Right,
It's
but going
easy to-
back, I think that is something we definitely need to look at. The other thing that I think would be so helpful is if we make the redaction platform that we have available to everyone and make it required for lawyers to wash it through the redaction platform, because that way, you know, then you wouldn't have attorney error. It would automatically, particularly lots of the points are numbers and data that are easily identified by you know, this platform. We really, I think, should consider that and think about how we move that forward, because some of the EFSPs have it available right to the lawyers and they can go ahead and utilize it, but others haven't. And because they need to do some, I don't know, retweaking of their systems or whatever. But I think including it, looking at whether we need to amend the rule, and if the thing is, you hate to amend a rule to include a bunch of stuff that A, may become stale, or B, you'll have even more additions and more additions. I wonder if there's a better place to or a better rule that you could say, okay, now go look at some standard or something maybe that would keep it from just being stale all the time. So anyway, but it's worth taking up, Tracy,
Right.
and because you mentioned that and you sound like you're a guru on it, you will be head of that committee. Thank you.
Well, it's either that or you only allow subsequent filings to be seen by the parties in the suit, right? If they get seen right when it gets submitted, then make those part of the attorneys in the suit or the attorney level and above.
Mhm.
But like insurance policy numbers, you know, military ID, stuff like that is in the PII rules, but it's
Mhm.
not in Rule 21C.
Yeah.
So.
And Judge, if Tracy wants some help on the subcommittee, I'd be happy to help her.
That'd be great. I mean, because I think lawyers, if anything, are overstand. If somebody sees a military ID and you're in San Antonio, you know to stamp that thing confidential, right? A lot of lawyers will. You know, and so I think it's happening, but it needs to be either a rule, standard, or something where people are made aware of it.
Casey.
Can I chime
Redaction.
Yeah, in there.
No, the API is there. It's just a matter of the EFSPs being required to do it. My understanding, there's 2 others in addition to the state one that does it.
That's right, yeah, the redaction solution is included in the program and there's APIs available, so you can use it.
There.
I think we should give them a time period within which to configure and get that thing going so that we can really take advantage of a belts and suspenders kind of system. I think that'd be helpful, very helpful. But going back now to our
The topic at hand.
to the watermark. Hey, can you reduce down the size of that so they can see the watermark? Because right now it doesn't look like.
Yeah, well,
that.
there's 2 pieces. There's the lines up at the top.
Okay,
That's the.
Oh, thank you. Okay, yeah, that's right. So this document has not been accepted for filing and has not been reviewed by the court. Until the document is accepted, it will not be recorded on the court's docket or appear in the official record. So that's the
That
suggested
really should
language.
be- Yeah, that really should be
And what?
in red, because we all miss that. And so you.
Yeah, exactly.
Yeah,
We,
Part of the caption or something. It's like,
I was gonna suggest a different font than Times New Roman.
Oh, yeah, that's a good
because
idea.
That's the most common font we are in,
Mhm.
and like, I was gonna say like all size are bolded, but I think a different color is an even better idea.
Yeah, I think red is the best.
Red's fine.
Really stand.
Okay, so the idea, I think red and in bold is probably a good idea. So red and bold. And then what about the text of this statement?
Oh, sorry, the top statement.
I have a little concern saying the document has not been accepted for filing. Should we put by the clerk or, I mean, because it's been quote filed, maybe, possibly. I don't know. I'm just bringing that up. I guess, you know, it's coming out.
Process.
Yeah, I think, yeah, instead of, and I wouldn't put it, it's not been reviewed by the court, because even after it's filed, Judge Ferguson isn't reading the new petitions that come in each day. So, you know,
We don't review filings.
yeah,
Well, subsequent filings too. not just-
yeah, whatever.
But maybe, yeah, okay. All
I
right.
hate the terminology that I use, but for me, it's submitted for filing. When it's accepted, it's filed. That's the terminology that I operate under, so. When it says it hasn't been accepted for filing, that makes sense to me.
Yeah, okay.
Because it's been submitted but not accepted, it could be rejected.
Yeah, not reject, yeah, it could be rejected, but mostly it's returned for correction. There you go.
Return for correction.
There you
That's
go.
right.
Hard using the wrong R word
So-
there.
Yes, yes.
Judge in the chat, Velva puts proposed language. This document has not been reviewed by the clerk, period. Therefore, this is not an official document until a file stamp has been placed on it.
Mark's got something to say about that.
Yeah, we overlooked Mark a few minutes ago.
Uh-oh.
Sorry. It's okay. Is my question first is, when and where would this document appear?
This document would appear in Research Texas upon filing,
Uploading.
Upon attorney submission.
upon attorney
But
submission,
this is
In
a
the press
separate-
queue, right? In the press queue.
just in research,
Just in research.
just in research.
Okay, so there's no listing of documents that you have to go in and search for.
You would have to go search for it just like you would in research.
Would it be automatically available to anyone else, another attorney searching research?
Okay.
Everybody.
Public.
Everybody.
It would be available much like any other document is available in Research Texas today.
Same security matrix.
Same security matrix.
And why would it, why would we put it up there before it was accepted by the clerk? And B, would it be automatically switched out with the file stamp copy once it was accepted?
Those are good questions. So Mark, we have made our recommendations to the court that we probably wait until the clerk is accepted to then make them available. But right now, the court has come back and asked us and basically phrased it in terms of, well, if we go ahead and just provide a public access pre-clerk acceptance, what kind of watermark would you want?
So I just, because we had this issue come up several years ago of watermarks and unofficial copies, et cetera. I wouldn't want a slippery slope to pop up or pop down, if you will, and have to go down that. And so I'm wondering if it would be automatically replaced then once accepted with the clerk's accepted copy, because the biggest problem on the ground that we're having right now is the inability to get documents. They're not being transmitted up to Research Texas. Not just orders, which are in some counties being withheld, but also not being able to get pleadings due to mismarking of PII, et cetera, et cetera. And so that is a huge problem, those things.
I agree with you there. So technically, and I'm sorry for not doing this before, and technically, this would be a pre-clerk processing review. Documents would be available on Research Texas. I'm trying to hear it. What search, would you just put the search term in of knowing who maybe one of the parties is and hope for the best when you type it in? Is that kind of what your search would be? Because there's no case number or anything else.
There's, I mean, you could also, there are ways to search and just essentially generate any new thing that came in that day.
Oh, that's true. That's
possible.
true. New filings.
So
Okay,
you
so
could
you
look
would
at
do
the-
that. It would come up, and then can you explain what would happen once the clerk processes through the
Yeah.
queue, process that document? What happens to the watermarked, non-processed document?
So and Terry, I'll explain and then keep me honest if I go off the rails, but we've been through this several meetings internally between OCA and Tyler. But the way it would work is that upon submission by the filer, it would immediately go to Research Texas with this watermark on it. And then once the clerk, there's 3 scenarios that could happen. The clerk hits the accept button, then the file stamp copy overwrites the watermarked version, and the watermarked version is no longer available. If the clerk returns it for correction or rejects it, then it kicks out of research and is no longer available. If the filer goes in and claws it back, because the attorneys have the ability to say, whoops, my bad, and then undo that filing, it would get pulled out of Research Texas. So for the 2 hours, 8 hours, whatever the time it takes for the clerk to say, this is wrong, I'm returning it for correction, it would be available with this watermark on it in Research Texas.
Okay, so after the clerk then accepts it, say that they're not going to return it or anything else, they're going to accept it, then does the watermarked version also disappear in Research
Yes,
Texas?
and it's replaced by
And
the
it's
stamp
replaced by the
version.
stamp. Okay. All right.
Does that address Mark's concern?
Mark, does that address kind of how that process works so that that water stamp goes away once it's processed?
It does address that it will be replaced. Question, if it's once accepted, assuming that all the documents will go to Research Texas, then it would go and be replaced. That's not an assumption.
Data say the data sensitive document.
Well, that's a different issue.
Yeah, and so still, Mark, if the lawyer marks, for instance, if this document was marked as contains, personal information or whatever is confidential, then it would never appear in
research
at all. So it
Right.
would not appear at all. So that's unfortunately, so anything that a lawyer stamps as confidential does not even get into this immediate public access.
That's part of a larger discussion we probably need to have
Yes.
about that some other
Yeah,
time.
we'll have a larger discussion about your concerns about trying to make Research Texas a much more robust PACER-like system that you can rely on for looking at court records. And we can talk about that at another meeting because it's a very worthy conversation. So let's go and look again at the statement at the top. What other ideas do people have about that language?
Someone in the chat had some suggestions.
What about, okay, was that Velva?
So Velva's language in the chat was asking, hold on. This document has not been reviewed by the clerk, period. Therefore, this is not an official document until a file stamp has been placed on it.
I don't like that because some documents we don't pass, exhibits being one of those.
Okay.
And I should add, we were asked about a watermark, but again, I threw this in. Another option is to just not have a header or footer and just have a big watermark across the page.
I think
So,
both of them are good. I like the idea of having that statement just to make sure people understand.
Yeah. As to the watermark, like I said, I suggest a different font than Times New Roman. And then as to the header, I do, like, I think it was a good idea, even though no one specifically asked, I think it's a good idea to have something in there. I would take out in the first sentence, and has not been reviewed by the court. And just say this document has not been accepted for filing by the clerk, period, until the documents can go from there.
Yeah, honestly, I wanted that to be an out for judges that are faced with news articles that are going to be written, like on the weekend, that's just what I foresee is that they're camped on the system and they're seeing stuff that the judge hasn't seen or had an opportunity to see, and a newspaper article is being written about it. And I didn't want judges, to feel, pressured to be monitoring this stuff all the time because of what might be in the newspaper.
I guess if I were still on the bench, I would appreciate that, but there's kind of the implied thing is that, well, once it is accepted, the judges do review it and they don't.
Yeah, no.
That's all.
Yeah, I was just trying to get in the mindset of a journalist and what a journalist is writing, what they're saying, and then how people might react to it. And it just sort of felt like, well.
Have a presiding system and then you'll never know which judge has got any documents, so. It's-
I got both.
Most of the journalists I knew, the judge didn't say anything, it's not worth it.
What do you think, Judge?
I like it there. I would change the to A. I'm not sure how much difference that makes, but otherwise it makes it about a particular judge. Hasn't been reviewed by a court. It's a much more generic statement that protects everybody instead of a particular person. But it doesn't bother. It's a true statement. It doesn't make sense to the extent that we never review them. But it is a true statement. So I really don't have strong.
And maybe someone who is not a lawyer or something, maybe that gives them some satisfaction that, some crazy divorce thing that was wrong has been made public. At least they know their court hasn't looked at it. I don't know, or a court hasn't seen it. I don't know.
We can tighten it up by taking out and has not been changed to or reviewed by a court, has not been accepted for filing or reviewed by a court.
I think you could also just drop everything after that. And get rid of the and the rest of it. I mean, you said this document has not been accepted for filing until the document is accepted. It will not be recorded on the court's docket or appear in the official record. I mean, if that's problematic. I don't know that it makes much difference. Are people going to pay any attention to it anyway? But that was my thinking of putting it there.
Okay, I would put the period then after filing, because people can file with courts as well as clerks. So.
Can I just throw one other thing in it? This is pretty nuanced, but the word until bothers me a little bit. I kind of have a preference for the word unless. It makes it a little more conditional that it may not be accepted. Until kind of suggests that it's out there. It's just a matter of being rubber stamped, but
Good catch.
I don't have any opposition to what you're saying.
Less accepted.
Yeah.
Take out the other, the documents.
Unless accepted.
No wonder.
And a comma still goes after accepted, right?
Essential area.
Unless accepted, comma.
Yeah, do we want to mark that up?
Yeah, let's please do.
So it's in a PDF.
Yeah.
Well, do you not have the PDF?
I do, but.
If you don't.
If you right click, you can hit edit document.
You can edit it with your. don't you?
Yes, I do.
Adobe, get in there.
Right. Yeah, we don't want people to be able to do this.
Right, exactly.
That's better than the thing.
What about a small caps red?
Okay.
And bold.
So my question was gonna be, should the watermark be on top or should it be underneath? Watermarks are generally underneath, so you can actually see the writing. But it appears to me that this one's on top.
I think it is underneath. I think it's underneath. looks like the line and the words that we can see go over the top of the watermark. But watermark's just very dark. I think that's.
Yeah.
No, you can have some that's grade washed out, so. There you go, I like that
We'll
one.
spot that.
We try leading.
What is that?
Right.
Put in chiller. Scare 'em.
I think that looks good, but doesn't it need to be bolded?
It is bolded.
Is that Arial or what?
Yeah, I mean,
Maybe we underline it too.
Italicize as well. That's what I do. I mean,
Italics makes it harder to read though generally.
yeah, it
but
depends on the language. I mean, the fonts, that font would be easy to italicize.
That's good.
that's pretty ugly. They probably won't use that. Boy,
Should we start it by saying warning in capital letters?
I think that's fine. That language is fine. And remember, who we're aiming this to is for someone who's really going to be the aggrieved party, is just being able to point to something and say, no, what's being reported is not real, at least yet. And then, that's all they want, something that's on the document that they can point to, and then something that stands out. And I think this does.
Yeah, I think some of those details too about font and color and all that kind of stuff can be worked out later. I think it's just more important that the language be recommended.
And one terminology question, is the issue whether it appears or whether it forms a part of the record? Because you can have something in the record that doesn't appear, that's been part of a problem. It seems like what we're saying is it's not accepted and it doesn't form a part of the official record. It's appearing to me means something different.
Yeah, you proposing to change it to or appear
Or be a part of.
I think the language we usually see is form a part of the official
Form a
record. I'm not worried about that, I'm just worried about the word appear. Does that mean it's there and I'm not allowed to see it?
part of.
I would say form part of the official record.
What
I'm
does
not
that
very sure,
mean?
I'm just putting that out there for discussion. It's much more wordy, Dan, so. I mean.
I would just say form part of, take out the A.
Just tarnishes my.
And actually, why are we saying the official record? Because there is no such thing as the official record, right? Any official record. Or an official record. I mean, that there's no one single official record, singular.
Okay. What record is it? It's a court's record, right?
I think that would be an improvement over official record.
What about court's file? Because you get into the appellate rules and you've got the clerk's record, the reporter's record.
Will not be recorded on the court's docket or the court's record. Or record.
I mean, I think that's true. I mean, we talk about courts of record, you're making a record out of that. I mean, remember again, this is not targeted at lawyers. This is like targeted at the public and journalists.
And I like file better than record. The clerk's record, no one ever asked the court for the record, it's the clerk's record.
It's
But
what?
It is a file, I mean,
It's the court's file. The
It's the court's
clerk
file.
is the clerk of the district court. It's, or the county court or whatever.
It's
I
a
don't
court's
think we're
record,
deleting
but
record. I
but
think
the
we're
clerk
getting
is the
rid of-
custodian of the court's record.
I think we get rid of-
Yeah.
Court of Appeals, when they ask, when they send their letters, they ask
Yeah.
for the clerk's record.
Ex-
No, I agree with you, but that's the terminology.
Yeah.
they use.
Yeah.
Clerk's record. Which
That's
we
his
can
section.
accept on appeal, in which case we're happy to say.
Yeah, I mean, when you're talking about this, it's the court's record, that's the clerk is the custodian of.
Right.
When you actually talk about, look at what goes on during the course of a proceeding, you have the judicial records that are not subject to public information, so you have those.
But I would
So I
say,
think this makes it, when you talk about
Yeah.
court records and clerk records, I think that's.
Okay,
when
do
you
we
start
want to
talking
just
about
make
the
it part of the
distinction.
record? Is that what we're talking about? So we
Part of
don't
the
get into
record.
that or?
I think that's fine. I also think too, we have to remember, only lawyers and judges care about these distinctions. And that's not really who we're targeting.
Yeah.
We're talking to journalists who don't know what you're talking about.
Yeah.
And
I agree.
Don't know either.
Okay. And then are we gonna put the watermark, is the watermark black or red? Or does it matter?
I vote for red.
Okay,
My vote's for
red.
if I get a vote.
I don't care. I don't know how you can miss that.
I know. Either. Okay, are we happy now with the watermark just as is? Do we want to change the color? What do we want? Anything else?
Is there a reason that it's diagonal?
Yeah, to try to cover the whole thing.
It makes it tougher to remove.
Right.
Yeah, see, it's Casey's strategy to.
Yeah, because of the way.
He's got it all. Blake's done a good job of getting it chunked in the middle of the.
Exactly, you're in trouble now. You gotta redo what the,
No, that'll bring me the text behind it too.
yeah, that's the
Anyway.
problem.
Well, that'll satisfy me.
Y'all want red so that everybody can see it and not.
Okay.
Poor Casey, we're just watching.
I think that's-
I'm not an Adobe expert by any stretch.
So why don't we, do I hear a motion that this is the watermark and the text that we want to submit to the Supreme Court?
We referred to it earlier, I just want to make sure all of this is flat, it's part of the
Yes.
document.
Yes.
It Can't be excised.
Yes.
That's right,
Mhm.
as Casey has proven in trying to make it.
Did a decent enough job, but no, as part of our testing.
Right,
The other thing, and I'll just let you guys know, is that in the event that the Supreme Court were to order that this move forward, there's still some development work on Tyler's part that we're working with them, and so that would be part of the testing that we would say, okay, it's ready, okay, show me one.
all right,
Hey, Tracy, do a number on this and see what you can do, and then
right,
we'll try
okay,
and tear it apart.
And also to this point, this model document, it's on every page, and I think that's what we.
Right.
wanted to
Yes.
agree.
the watermark's on every page.
It's on every page.
Yes.
And the header and the watermark is on every page.
All right, let me ask this, though. Can you pull that up, the watermark? Because, I mean, you can read around it, correct? Because that's the media will say, what's the use of having access to it when you totally have obliterated and I can't read anything that you've done?
You can still read it.
Yeah, I mean, you can make it lighter and darker and, can we go to another page and see?
Yeah, I think
I mean,
that's.
I think we can make that up.
Okay, go to like where you start, where the text is. Let's see what it looks like.
This could be a hair lighter.
Yeah, okay, so,
Most
Yes.
traditional watermarks are about like a 15% screen, so it looks like it is screened some, maybe 70%, but you could pull back on that and it might help some.
I can read it fine.
okay,
And if you wait to the next business day, then it'll be file stamped and the watermark will be gone.
all right. Okay, so do I hear a motion?
I move the standards language and the watermark and language as amended.
Okay, so the motion's made to submit as amended the watermark and the language that we have worked on to the
I
Supreme
second.
Court. Okay, all in favor?
Aye.
Aye.
Anyone opposed? Okay,
All right.
all right. Thank you. Okay, so those were kind of the key things that the subcommittee has worked on. There are a couple additional small matters that I think the Supreme Court mentioned that maybe the subcommittee will get together one more time and just make sure we thoroughly answered what the Supreme Court has asked us to answer. But I don't think there's any other work product that we would be submitting to the Supreme Court. But what we will do then is make these revisions. We will circulate it to everyone so you can see it as well. And then forward this on to the Supreme Court. Okay, so Standards Committee. Do you have any?
Yes. Casey, can you put that up, the bullets?
Oh, crap. I've got them on my phone. I don't have them on the
Okay.
computer.
Which ones?
But let me get it right quick.
Those suggested standards.
It was the I had sent Bob some bullets on. Standards. There we go. Bob, is it okay if I just read off?
That's fine.
Okay, so the standards committee did meet several times over the last month or so. And they have version 8 that's ready for adoption, and the changes are pretty innocuous. And first in the family section there, we added, or the committee added a SAPSR version of the motion to revoke, suspend, and withhold. And that's due to there's a different fee if it involves a SAPSR versus a non-SAPSR. So we had the non-SAPSR version already, but then we needed one with the SAPSR version and a different fee. So the committee added that. There was a revamp around the language for multi-district litigation. The standards were trying to delineate each MDL, and the discussion with the committee was that in Harris County, at any given time, they've got 10 to 15, and then Laura Hinojosa's got a couple, and they're all over the board, and they're always coming and going. And so that language was revamped to give the clerks control over what those MDL case types are, because the understanding is that when the Supreme Court orders an MDL, it comes and goes, and it goes to a particular county, and that clerk can then just add that code so that they don't have to go through any red tape with asking Tyler asking us saying, yeah, that's good. Just take care of it.
Well, and us having standards on every agenda for JCI.
That too, because it changes all the time. The committee added a return for correction reason called unable to process due to the e-file system. And that came up mainly because we were seeing, and Tracy, you can jump in on that, where there'll be errors here and there that come in that it has to be turned away at the system once it's at the clerk.
Right, so there could be technical difficulties. Just the size of the filing getting through the portal could be, that it's locked down, they can't file stamp it. It could be tons of different things that cause the filing to error out in our error queues.
Right. And so this would be put in place until we get the changes to the EFM to turn a lot of that away at the door.
Right.
Before it shows up in the error queue. And then finally, the last change, there was no really change, was the committee went and did review the registered user matrix for research and went through all the different case types and filing types to see, is this still appropriate? Are we missing anything? And the only clarification they put into that was the definition of delay days, because in our technology standards, we have for certain case types, a delay of how long it takes for it to show up on research after it's been accepted. And the committee clarified that the delay days are days from the time the document is accepted by the clerk. And that clarifies just from the standpoint of, if we start submitting things at the point to where the filer hits file and then it goes immediately to research, that number of days delay clock has not started yet until the clerk hits the accept button. So even though the standard says 180 days, it may be 182 or 181, depending on when the clerk accepts that document. And that was all the changes. That was the 5 bullet points that the committee did.
Okay, I'm going to bring up for the standards committee a thought, and that is, I have now heard from countless numbers of lawyers that are very disappointed in the e-filing. And I'm asking them, I thought you liked e-filing, everybody hesitated. And what they dislike is that our lawyers practice in multiple counties now, and they get returns for correction for items that are not appropriate, that are not listed in the standards. They get returned for corrections because of lead documents or whatnot, and it's totally different from another county. And they are really getting angry about it. They're getting these returns for really apparently no way for them to know unless they call each and every clerk. And so I think we need to try and do something to get it standardized where it is an enforceable standard that this is the way lead documents work. This is the way that things work, and that you cannot return for correction because you don't like the font somebody used. It's not one of the listed items, and I don't know whether, how to really deal with it, but I'm gonna ask standards to take a look at that and see if there's some way that we can really start tightening up tightening up the reasons for returns for correction, and tightening up how are we dealing with lead documents? How are we dealing with, exhibits? Because lawyers are very, very frustrated right now with the lack of their ability to even know, but B, just the lack of uniformity. So I just bring that up because I've gotten an earful. So I don't know if you have.
It's not only lawyers. It's like debt collection, aggregators are going across counties, they get different requirements from different courts in different counties for the same issue.
Yeah, and the people that handle the bulk filings for taxes and things like that, and all of that, they're getting the same problem. One county's this way, another county's that way, and really that's not how our e-filing system is supposed to work. It's supposed to be smooth across the board.
So, Justice Simmons, do you believe that perhaps a survey across the clerk's offices as it relates to the reasons they reject or which is a return for correction, we compile all of those and then we come up with standards of what we know to be the reasons for rejections, and we say, okay, we start isolating some of those.
But we already have. There are only so many reasons they're listed in the standards.
The only way you're going to get to that standardization is to know what they're returning for correction.
Or how about telling them you can't, whatever else you want to do, it's not available because you come to us and change the rule to add something else. I think that's the issue, is that the clerks have been given guidance. These are the only things you can return for correction, right? So they already have been told what is available. Now, if they're doing something else, then I grant you, it would be nice to know what it is and see if there's some way we can help them to work around that and whatever. But I don't want to go into, well, I guess I worry that the phrasing, just tell us why you're rejecting things and we can make a 200-point list on all the reasons why.
That is my concern, because when we first developed those reasons for rejection, if you recall, we had many face-to-face meetings down here and tried to cover what are the things that are going to happen in the process that we can anticipate. And after the first round of counties came on, we went back and added a couple. But if we say, what are you rejecting for? I sure don't want to get every reason that they could imagine. But at the end of the day, because we've had this discussion before, someone is going to say, and how do you enforce it?
Yeah, right. There's no
Mark's got his hand raised.
Go ahead, Mark.
We have access since the launch of the first iteration to the data and reasons for rejection through Tyler. We have access to that upon request, or some of y'all may have access to upon request.
We've already looked at it. We've looked at it, but the things that we're finding out is that, you may have some parts that will hijack reasons and say, filer's request, and I'm going to type my comment in, these 8 reasons that have been set out be damned. This is just what I'm going to.
We're building our education, our topics for our education. We finished for our conference in McAllen Hidalgo County, but perhaps in the fall, when we have our fall conference, maybe we should have a session, a focus session
Yeah.
on that being a topic of education for return for correction.
Right, but also,
I'm sorry to interrupt, but that can definitely be discussed during a roundtable discussion. We can also put it out on our listserv with regards to the standards that were adopted in November and what the reasons for correction are. But when it comes to things being returned at the filer's request, that is one of the reasons that we can return. I don't think that we need to list what the filer's request is. But as far as the clerks go, we can definitely talk to the clerks and hit on the technology standards.
I'd be interested to see what the stats say about the reasons for filer's request and often listed as judge's request.
It doesn't say, Mark, it's that broad language and that's it. And it's, the clerks click on one button and that's what it is. I don't think there's any clerks that list, the filer didn't like the font he used. I mean, it just says filer's request and it gets sent back.
and that's what they hide, and then they call them up and say, I don't understand why, I didn't ask for it. You said it was filer's request. I didn't ask for it. Can you please tell me what it is? And they get font or something. Nothing irritates a lawyer more or their paralegal than to get something back for an undesignated reason for, and then say it was at the request.
I'm gonna do that. I'm gonna do that process in my office where we actually look at the reasons we are
Yeah.
returning for correction. And I tell you, you will never see me behind the desk doing e-filing unless there's a camera and I'm on it's a news story. But otherwise,
We've looked at the issue of enforcement. There was a suggestion, well, maybe we should create a contact for lawyers to specifically lodge their complaints. Well, who wants to be at the end of that number?
and that's why I'm like, okay, I need to get I don't want to be in the newspaper.
Sounds like it. Judge Simmons is the end of the line right now. She's getting the-
I do get calls. I get calls.
I got a phone. We need to get in the.
Yeah,
No offense, I'm not sure going to the clerks is the right source. I think we need to go to the people complaining. And
We should.
what are you complaining? Give us an example.
And are these people that are they contacting the clerk? Like if my clerks were rejecting for.
They've got
inappropriate reasons.
some of them, one of them is a bulk filer, tax cases. They don't want to go back to the clerk and say, you know what, you suck because you're doing this, I mean, so they don't really complain that much to the clerk, except to say, we don't understand,
How are we gonna know that we suck though?
So, yeah.
Don't tell us.
Because that's very offensive.
You can go, and that is, if you go to the Texas Lawyer, the Facebook and they,
Sure.
You-
Circulated lots of that stuff.
yeah, you can see comments there about these returns. It'd be interesting to look at the data again and start, I think at our JCIT meetings, it'd be good for us either through Tyler, Derek, that's you, or Casey to list out what are the returns for correction. And let's just see where they are. That's not to close, and you were right that we should seek out, if there is a process problem that we need to be aware of, that we may need to revise these returns for correction, that the clerks are having a problem with, then yeah, we should look at it, but.
I tried to do that back when we initially met this other subcommittee back in October. And I think I emailed that around to the other subcommittee folks. We found that 29% of the rejected e-filings of the 870,000 rejected filings we'd had came from filer's request, whatever got grouped into that group. Then the other, like 28% came from the categories of incomplete formatting or incomplete information without specifying what information was incomplete. 13% was judge's request. And then we've got one down at the bottom, and there's a whole multiplicity of reasons, but then unspecific reasons or simply rejected as a box that got checked in about 2% of the time. And to me, I never could make heads or tails about what those unspecified reasons were, but it's a field that's available to allow a clerk to reject for that reason.
So I think that the incomplete formatting or incomplete information, that is sometimes, like I think in Bear County for certain family law cases, there's a requirement that you include a certain a certain document with that filing. And if it's not included, then I think they return for correction. And Mark, you know that better than I do, but sometimes judges have specific orders in family law cases that they want the parties to agree to, or want that attached to a pleading, and that they might return it if it's not attached, even though that's, not somewhere. And another thing we need to be aware of is that the court has changed the rules relating to local rules. So in the past, to have an enforceable local rule, it went up to the Supreme Court, and then it was approved, and then that local rule took effect. Now it is more a default that the local rule is in place unless the Supreme Court modifies it and it's online, right? So the good thing accomplished was that everybody could see what the local rules. The bad thing is that I worry once that becomes known, that local judges will just start adding all kinds of stuff to e-filing issues that could affect us. And I have brought this up to our liaison, Justice Floyd, about that, and maybe kind of look at it closely just to monitor that, to make sure that all of a sudden we don't have local court rules that are affecting e-filing.
It is really hard to tell sometimes how much is really an e-filing issue
Right.
compared to a local practice issue.
Yeah.
The same sort of things you might have encountered over the counter in the past, where someone might have said, you need this form, or
Right.
you need this
Yeah.
double stapled or 2-hole punched or whatever, some types of just like local practice type stuff that really doesn't have anything to do with electronic filing
Yeah.
per se.
I'll throw in, if possible.
Go ahead.
I was going to say, I think in the 2 iterations, in the last 20 years of e-filing, I think the rules that we've put out have meant to occupy the field and not create a system where we'd have 254 times 2 or however many clerks to judges. And it's not for me to tell anybody what to do, obviously, in terms of or in terms of judges, especially because we go into court asking the judge what may we do. And so but if that's the case, and that presumption is accurate, that these rules were meant to fill the space and apply evenly, then the issue is, it may be that there's local issues and not an e-filing issue, but the e-filing issue, as designed and implemented and enforced or not, is allowing for those local problems to crop up. That's
Well, if Larry said there's just a generic rejection reason as a rejection, as a return for correction, that's not on our standards. So is there a county out there that
There
has
should be.
rejection reasons other than the standards that we don't know about?
There shouldn't be, and we can validate that. All of these statistics are on our e-file analytics
Right.
platform, and you can break it down by individual office and even by individual clerk who's performing those rejections. So if we want to do an analysis, we can go pull that data from that platform. I think those of you have access to it, and we can identify exactly where the problem is, if there is a specific continuity between a specific jurisdiction or even a clerk.
Okay.
Yeah, because we don't have that kind of a reason. We only have the standard.
Right. Yeah, we had I can't believe I'm gonna bring this up, but I am. And in terms of letting clerks know how they suck, we had, well, that we were talking about, how do you tell the clerks they suck before? And we had talked about having the clerk's page,
Right.
to give them that information, and Terry, no offense, but it's not very functional what you guys came up with for the clerk's overview
Oh, really?
page, and I think it really needs some work. And I think some of the standard information that they ought to be able to see is this information about you know, how much have you accepted today? How many have you returned for correction? Why did you return them for correction? And it ought to be very simple for John or myself or whoever to just pull up the page and see that just right away. Not have to go run any reports or
Yeah,
anything. It should
sure.
just be
And
there.
I'm happy to set up a meeting
Very
with the clerks and we can go through it and you can say, this is no value to me. This is what I want to see, and we can change all that.
It'd be interesting to me to just see in the top 10 top most populated counties maybe or something, or choose 20, just to see what is the median number of returns for correction. What are the, you know, just do kind of a data analysis of what is the norm or whatever currently, just to see where we are, because it may be that we have outliers. And there may be an issue where we can just talk to the clerk directly and say, okay, just like John said, okay, what's going on in your office or your business process that is resulting in you being way out here for your return for corrections when everybody else is here at this median kind of level?
Yeah, I think it was Justice Doss pointed out in our analysis of that data that there were also some counties in particular.
For processing,
For the processing times that were way behind
Yeah.
everybody else. And then we removed a bunch of them and that really brought the average
Yeah.
down. And that's another thing where I think there needs to be some outreach in terms of processing times
Mhm.
to let them know that too. I mean, that's another bit of data I think would be really good to have on your homepage as a clerk when you pull it up and see how do I compare in terms of
That's-
processing time with
Mhm.
everybody else.
That's, I think, would be a good idea, is maybe get some of those standards. I mean, information going, and more along the like counties, because, you know, if you only get 3 filings a day, you know, you don't want to compare it to Harris County, you
Yeah.
know, and their filings, so,
Rebecca,
yes, sorry,
looking back on the local rule thing you just brought up.
yes,
One thing I just read the amended rule 3A.
okay,
And it says local rules formed in standing ordinance not being inconsistent with state or federal law, rules adopted by the Supreme Court.
right,
Doesn't say can't be inconsistent with the technology.
exactly,
So perhaps we should recommend to the Supreme Court that they, even though we missed the commentary period,
yeah,
they throw in their standards for electronic filing.
that might be, that sounds great,
Because yes, we had a case before with e-filing was mandatory for some of the civil district courts in Harris County requiring e-filing.
right,
And that was inconsistent with the rules, and there was actually the court that got a summary judgment reversed because he had required e-filing and that wasn't kosher. So there actually is case precedent
mhm,
about that. My clerk got really grumpy with me because I would require e-filing and I said I can't.
Yeah.
And she said, well, all these other courts are doing. I can't speak for them. I'm reading the rule. I can't.
So do you mind taking that on, in that you go and look at the court's recent rule on that, and maybe look at some of the history of that, and see if you can come up with kind of a recommendation that we want to make to the Supreme Court about, you know, language, and talk with Bob about the standards that are in place, and you know, kind of craft something, because that might be an easier fix in terms of not all of a sudden getting so many local jurisdictions adding things
I
to
don't want.
affect the.
In the rules of administration.
Okay.
And the statute that
All right.
talks about the duties of the local administrator.
Okay, so do we have any other business?
Yes,
Oh, yes, sorry, go ahead.
redaction, what do we want to put that on the agenda for June? As far as what would it take to implement? it?
Yes, yeah,
And
let's do
some
that.
sort of
Yeah.
phase-in approach if needed.
Yeah, so since redaction is free, I think we ought to push that as another
Yeah.
way, particularly if all this stuff is gonna go out. Before the clerk has the ability to process it, we ought to probably get it washed at the EFSP level through that redaction platform, and that might help prevent the disclosure of personal information, so.
Rebecca, I have one.
Yes,
This
yes.
item.
Okay.
I emailed Casey about this and I got an email from someone else. I was on the subscription list for the bi-weekly Court of Appeals
Yep.
opinion dump.
Mhm.
I haven't been getting them for over a month, but someone emailed me, said that there's a problem with the system. I was just checking, do we have a status?
Yeah, so they changed their APIs. That's when it broke and our programmer's working on it now. And I think she said it was gonna take another week or two to finish up
Okay,
recoding to those new APIs.
will we have to resubscribe?
No. You won't have to resubscribe. So for now, you can, they're still all available
Yeah, you can go.
online. You go find them. Yeah.
Tuesday and Thursday morning.
You get your emails, yeah.
Versus 14.
Yep.
Thank you.
All right, any other business? Okay, with that, we stand adjourned. Thank you all for